Good morning. Welcome to the Retirement Report. I'm Hank Parrott, your host. All right, we're going to delve in. We've been talking about trust, and there's one of the things in wills and probate and all these things, right? And real estate and what impacted these things are going to have on your real estate is one of those areas, but all assets, of course. So one of the things, too, that talked about just before the break is this of having a plan. And the importance of having a plan. So if you don't have a will or a trust, if you don't have any documents set up, or maybe you tried to write your own will and it's not, and that could be a problem as well. Well, guess what? State of Tennessee, as with all states, they have a plan. There's a plan in place for you. So if you don't have a plan, they have a plan. And guess what? Here's one of the factors about that plan that, and we're going to have Jack talk about this in more detail, but think about this. Let's say that for a couple, all right, the two of you have worked your lives together. You've saved up. You've accumulated these different assets, real estate, other assets, savings, all your vehicles, the whole 9 yards, right? All your assets. Now imagine that you have no will, you have no trust, you don't have any estate planning documents, and one of you dies. What happens? Well, depending, right? If the state law comes in, any assets that were held in particular by the deceased spouse, what might happen there? They're subject to, well, in the state, we open up a probate case, there's no will or trust, and there's state laws that come into effect, and what do? As I understand, Jack, they're going to divide that between the surviving spouse and the children. It doesn't just go necessarily to the surviving spouse.
That's correct, yeah. Any asset that the decedent owned in their own name, if you die without a will, according to the state, it's going to get divided between your spouse and your children, which means that the spouse doesn't have control over it, the kids don't have control over it, and what's going to happen is the court is going to basically have to take control over that. And that can be very costly, especially if we're talking about something simple like a car or a couple of, a small bank account. Unfortunately, we see this a lot where the husband and wife will own most of their assets together, but obviously not everything. And a lot of times there's a car and a checking account just in the one spouse's name. Each spouse has their own car, their own checking account. So when that person passes away, maybe the house was titled jointly, yeah, it goes to the spouse, but the car, if that was in that person's name alone, and that checking account, if that was in that person's name alone, that is by law divided between the spouse and the children. And the cost of the intestate probate sometimes is as much as or more than the value of that vehicle or that checking account. Now, if it's a house, and this does actually happen in the state of Tennessee. In the state of Tennessee, an individual can own a house in their own name, even if they're even though they're married. So on the title, if the house isn't titled jointly, then that also becomes an asset that's subject to the intestate probate. And that asset, that house, is now owned by the spouse and the kids. If the kids are minors, that's a whole new wrinkle that gets thrown in there, because the court is going to want to appoint a guardian for those kids. So the cost of this intestate probate, letting the state decide how to manage your assets, just goes up and up and up. It's very expensive, very frustrating process.
So again, this is what happens when you don't have a plan. Just taking the time to make sure you have a will or a trust, and understanding the difference again between wills and trusts as well. And then this goes to retirement accounts. If you've got IRAs, Roth IRAs, 401ks, 403bs, thrift savings plan, have you named that surviving spouse as your, have you named your spouse as your primary beneficiary? And what happens if they're not around? What happens then to the assets? Have you got contingent beneficiaries named? How you hold assets, whether it's joint ownership, making sure certain beneficiary designations are up to date. There's been some horror stories about people that were married, went through divorces, and still had the divorced spouse on as the beneficiary because they never got around to changing it, maybe even remarried, and basically disinherited, the people that they wanted the money to go to. So these are things, the same with joint ownership, with second marriages, this can come into play. There's understanding these rules and how they work. Very common thing that happens, someone maybe divorces, remarries, and they end up holding everything jointly because they think that's the thing to do, and they have a will set up then that says they want to actually leave their things to their children, and maybe the new spouse has children that they want to leave their things to, and yet the joint ownership piece could totally throw out the will. In other words, it's going to go direct to that surviving spouse and disinherit their respective children potentially. So there's all kinds of things that you need to understand to make sure that you're going to have the plan you want. Trust planning is one of my favorites, and the reason is there's so many nice benefits that can come from it. And we were just talking about, if you intestate law and the way that works, how it divides up assets between a surviving spouse and the children. I don't know that we want to be in partnership with our children, right? The whole goal is first it's to take care of each other, right? First, so the first to go, the survivor stays in charge. When they're gone, then we take care of the children. If the survivor wants to make gifts or do different things during their lifetime, they have certainly the flexibility to do it, but they're not forced to do it as they would with intestate laws. So, and this goes with retirement accounts as well. They can fall into this same category if your beneficiary designations aren't done correctly. And sometimes people put the estate of instead of naming a person. And there we're right back into this potential intestate law thing with regard to retirement accounts. So it's so important not only to understand these rules and then to make sure that you have a plan that works for you, but that you keep it up to date as well. And this is one of the areas that Jack and I, when we work with clients as an example, we'll meet together with that client. We'll go over what the differences are. Typically, I'll have a meeting with clients when we're doing the financial stuff. I'll get into estate planning. I'll talk to them about these differences. Then, based on what's going on in their situation, typically bring in Jack, and we'll talk about what's going to work best for them. He'll answer your questions. He gets into what the specifics are, and we talk more about the planning pieces and for your specific family. You ever notice there's sometimes it seems like a lot of times in families maybe there's one person that's not so responsible, one of the children that needs a little help there in taking care of those finances. It may be just financially irresponsible. It may be that they're a special needs case, or it may be that maybe it's substance abuse. It could be any number of things. We run it the whole gamut. This is where trust can again help us out with regard to planning, where you can put language in to help protect them and take care of them at the same time. So Jack, this is one of those areas when it comes to trust and real estate. One of the areas where we talked about the benefit of leaving it to someone in trust, where they'll get a step up in basis, so now they can avoid capital gains tax for the children. Mm-hmm. Another is when you have real estate in other states, mm-hmm. What the impact would be there, possibly multiple probates, right?
That's true. You're going to do probate in any state that you have real estate. You'll do probate in. So if you're a resident of Tennessee, but you also have a farm in Arkansas or a beach house down in Gulf Shores, you're going to do probate in those states as well. And unless you have the property in a trust. If we have the property in a trust, the trust avoids probate. Trusts don't die, just like companies don't die. So even though the person has passed away, just like a company, if the president passes away, a new person can step in and be in charge. And the same thing with a trust. A new trustee would step in, be in charge of the assets of that trust, and then that trust will manage those assets for the beneficiaries. And you can, as Hank said, if you've got 4 kids and they're all equally responsible and you don't have any problems and they all get along great, then the trust can have a hands-off approach and let them manage things. But if you have the same 4 kids, but one of them has had a lot of struggles in life, maybe has creditors issues, maybe has an addictive lifestyle, then we can protect that asset and the other kids from that one child. And maybe we can let that one child benefit and have the time to go vacation there, but not be in charge of anything. So with a trust, we can set these guidelines, set these rules in place.
Yeah. We've had situations like that many times. For instance, there's a client I had many years ago, and when he passed away, he had a son who was, there was some substance abuse issues. Now, I've had so many different ones like this. I mean, both in substance abuse, but also just financially responsible. Maybe they're married to, an in-law that may someday be an outlaw, right? And what do we do there to help protect them? All of these things can be done with the way the trust is drafted, all right? So you can take care of those types of issues where you can still take care of them. So in my first example, we were able to, he was homeless, he was on the streets, and we were able to get him an apartment and, make sure that he had food and take care of his utilities, and got him in to see a doctor, and, all the different things there that to give him a healthier start and take care of him. And yet we didn't give him the money to do that because we knew that wouldn't be wise, right? The trustee paid those things for him. They paid his rent, and they paid his utilities, and they got deposited a certain amount of money into his bank account to help cover groceries groceries and things like that. So he was well cared for, well taken care of, but not put in a position where he could harm himself further, or just kind of blow through money and then be hitting up on the family for help. So this is a very smart way. This is just one example, and we're going to get into some more, but first we have to take a break. So join us here. We'll be right back on the Retirement Report.
The time is